Hello, this is Lauren Spahn, and we are back with Live Performance Contracts Part 2. In the first part, we dissected the different types of agreements that are commonly seen in live performance, in the live performance space. Today, we're going to do a deeper dive into the various provisions that we see in these agreements and what they mean. Because of the increasing legal complexities in the live performance industry, lawyers, agencies, promoters, managers, and talent buyers have had to re-examine their template agreements and legal protocols related to performers, venues, and live performances. Today we're going to learn about the intricacies of the live performance industry, the primary clauses that we see within the industry's agreements, how the industry is evolving, and how you can protect your clients in the live performance industry. We're going to begin by first looking at how the main clauses associated with the live performance industry are commonly used and what's contained in them. We will then learn about the basic legal language in the agency agreements, including force majeure, inclement weather, cancellation, insurance, and choice of law. And then we will finish by learning about the increasing legal complexities that the live performance industry is facing and what is being done about that. The first common clause that we are going to examine is force majeure. Force majeure is typically defined as an act of God or something that happens that is outside of the control and unforeseeable by either party. Typically, there are a number of examples that could classify as force majeure. Those examples are detailed in the contract language. Examples include acts of God, acts or regulations of any public authority or bureau, acts or threats of terrorism, riots or other forms of civil disorder, labor disputes, including strikes, lockouts, or boycotts, shortages of energy or other essential services, failure of technical facility, failure or delay of transportation, death, disability, illness, injury, or inability to perform of artists or artist family members. These specific examples are commonly negotiated, elaborated on, or narrowed in scope within the live performance contracts. Other examples would also include pandemic and epidemic, both of which we'll get into further discussion on later in this course as we examine how COVID-19 has had an impact specifically on force majeure clauses. Now, in the various agreements, the force majeure clause will typically state that the performance may be canceled by either party due to causes beyond the reasonable control of the parties that would make the performance impossible or make the conditions for the performance hazardous. The provision would then go on to say that such clauses shall include and would list all or some of the examples that we just discussed. Now, the key elements here are who can make the call as to whether a force majeure event has occurred. Typically, we want language to include that both parties can make that call. Oftentimes, you will see in the agency contracts that force majeure starts out as a one-sided provision that only the artist can make a call on. However, if you are the talent buyer or the venue